Hello, this is Don Swanson, and with me today is one of the giants of the bankruptcy profession, Judge Eugene Wedoff. 3 decades of bankruptcy judge in Chicago, career of providing leadership to the bankruptcy community, and I'm delighted to have him with me here today. One of the things he recently did is represented the respondents in the City of Chicago versus Fulton case before the United States Supreme Court. Now, it's not every day we get to talk to somebody about that experience, but Judge, welcome, and I'd love to hear you talk about that experience, the case, and your participation in it, particularly oral arguments.
Well, Don, happy to talk to you about that. And thank you for giving me the opportunity to talk with you. I'm really looking forward to it. But as far as the Fulton case is concerned in the Supreme Court, this raised an issue that only recently really became hotly disputed in the courts of appeals. For the longest time, the issue here, the interpretation of a particular provision of the automatic stay, section 362A3, was more or less generally understood. And it was understood according to its language. A creditor could not exercise control over estate property. And holding on to collateral that the creditor had seized pre-petition from a debtor was holding on, exercising control over that estate property. That was the general view. But within the last couple of years, circuits took a different view. Both the Third Circuit and the 10th Circuit issued opinions saying that the stay only provided a protection against new activity, post-petition activity of the debtor. The creditor. So if the creditor had seized the property prior to the bankruptcy case and was only holding on to it thereafter, no new action, no violation of the automatic stay. That's the way the matter went up to the Supreme Court. Now, my clients had a particular interest in having this case decided in favor of the debtor's interpretation. They were among the thousands of car owners in the city of Chicago whose cars were seized by the city for not paying parking tickets or red light violation tickets. All these tickets could be incurred by other than the owner of the car. If the owner of the car let a husband, a child, a friend drive the car and they illegally parked, the car could be towed. Now, theoretically, the debtor would get notice of those violations. Maybe the mail's not delivered. Maybe the debtor doesn't have the ability to pay, whatever, their car's in a lot. And the fines were excessive. $100 to start out with, if not paid in a couple of weeks, doubled. If not paid after that, the car's seized. And if the car's seized, $1,000 is a towing charge. So and then a daily storage fee. So this goes on and on and on, higher and higher and higher. And the debtors, of course, with no ability to pay the fines to get their car back, file a Chapter 13. The automatic stay goes into effect, and for years, the city and other creditors who had seized cars would return them as long as the car was insured. The car would be returned, the debtor could go ahead with the Chapter 13, and God willing, they'd be able to complete it, get a discharge, everything's fine. Bankruptcy does the job it's supposed to do. But the city said no. They took the interpretation that these new circuits had come up with, and the result was the city gets to keep the car until the debtor moves the bankruptcy court for an order of turnover and incurs the costs and delay that getting that turnover order would require. So that in a nutshell is what was going on in the case. And why did we lose? Very simple. The court 8-0.
No, not just, you didn't really, you lost, there's a technical issue they ruled against you, but there's a lot more to this. But go ahead, sorry to interrupt you.
Well, your jumping ahead to where we are right now, and the case is not over by any means. But as far as the dispute that was before the Supreme Court, yes, we lost 8-0, strictly a matter of statutory construction. The Supreme Court accepted the argument that the stay freezes the status quo as of the filing of the bankruptcy case. Now, we said that was wrong. That was not the best interpretation of the stay. And perhaps the strongest line of cases we had, including a couple dealing with another provision of the automatic stay, 362A8, A6, has to do with exercising not control over property, but attempting to collect a pre-petition claim. When the city held on to the property of the debtors, it not only refused to give it back, it also suggested that perhaps they could get it back if they agreed to pay the city's claim in full, although the cars were worth much less than the city's claim, or if they made substantial down payments, which they would not have been required to make by means of adequate protection. So the city was asking for things it wasn't entitled to under the bankruptcy code. And that, we said, was an attempt to collect their claim. And that's a separate violation of the automatic stay. But moreover, that provision of the automatic stay was used by several courts to find higher education institutions in contempt of the stay for refusing to turn over transcripts. The debtor would owe tuition, would have graduated, but need a transcript in order to get a job. And the institution would say, you pay your tuition, we give you the transcript. The debtors file a bankruptcy case and they say, come on, we filed the bankruptcy case, you can't hold on to that anymore. You're violating the stay. They said, no, we're just maintaining the status quo. They lost. It was seen very clearly that their effort to get money out of the debtor that they wouldn't otherwise have been entitled to violated the stay. We said the same thing is going on here. The court did not mention those cases in its opinion, and it went with the city's interpretation. Okay, that's the end of that case. I'm unhappy about it, but at the same time, I see that there's a legitimate argument coming out that way, and the court made its call. It may have been it made its call because it wasn't quite as familiar with bankruptcy as judges who practice bankruptcy all the time, but so be it. I should mention what you were hinting at earlier. The case is not over. We still have the other provisions of the automatic stay to say that the city violated by virtue of the conduct that it engaged in after the case was filed. So.
Well, cool. That's fascinating. One of the things, it's got to be a rush to present oral arguments at the Supreme Court. Could you tell us about that a little bit?
There's a disappointment here, Don.
Uh-oh.
It certainly would have been an enormous experience to have argued in the Supreme Court's courtroom. It's a gorgeous room. You're in close proximity to the 9 justices. You look around and can see the reactions every judge has to every other justice's question. Terrific. I was in that position as the principal assistant to a partner of mine who made an argument before the Supreme Court when I was still in practice. Great experience. Well, I was completely deprived of that because I argued during the coronavirus problem. And so all that happened for me was a conference call, not even the video that we're having right now. All I got was a series of voices asking me questions to which I responded. Moreover, and this is something people might not be so aware of, the practice of the Supreme Court, while they can't have real arguments, is to allot each justice 2 minutes for questioning. And then it goes to the next justice and then the next justice. And that puts a real premium on the justice demanding a prompt and succinct answer. They may have 5 or 6 questions they want answered. If a lawyer takes a minute and a half arguing the first question, they'll never get to question 4, let alone 5 or 6. And so that's a pressure on both the justice and the attorney answering the questions. Moreover, there can be no interplay between the justices. If a justice asks a question that reflects on what an earlier judge had asked, that justice can't come back and follow up again. So it's a very different experience. Between the two, no question, I would have preferred to be in the presence of the justices. But I still got the thrill of arguing a case to the Supreme Court.
Well, thank you. So one of the roles I've seen that you have is, as I look at the docket for bankruptcy cases on the Supreme Court, at the Supreme Court, your name comes up with some frequency on amicus briefs. Could you tell us what that's about?
I'd be really happy to do that, Dad. I have as a good friend a lawyer named David Cooney, and I could say an adjunct professor at Georgetown, David Cooney. David has for some time now developed a practice of examining Supreme Court cases, Supreme Court cert petitions, for issues that really ought to be decided at the highest level. So this can be an issue regarding the extent of a discharge. It can be an issue regarding the effectiveness of the discharge injunction. Any number of cases, it could be a question of bankruptcy court jurisdiction. Whatever the issue is, it's an important one for bankruptcy in general. And David has concluded that the Supreme Court would be aided if it received an amicus brief that more thoroughly explored the issue, or explored an issue that hadn't been considered by the parties to the case itself. In that regard, he's assembled a group of law professors and retired judges who are willing to look at any issue that he's interested in, give him their views as to whether it should be a matter that the Supreme Court hears, and if so, what the best arguments are that might be made. If the group agrees that this is something that an amicus brief could be helpful in regard to, David drafts the brief, circulates it to the group, gets their comments, finalizes his draft, and files it. He's done that many times. On several occasions, I've been one of the people that has been in the group he's represented. And for some reason known only to David, he puts my name first in the list of the people he's representing. And so it comes up when you look at the docket of the Supreme Court.
Well, that's fascinating. But, so to me, it's important that somebody with expertise in bankruptcy presents arguments to the Supreme Court, and the justices don't claim to be bankruptcy experts, but presents arguments that look out for the best interests of the bankruptcy code and the best interest of the bankruptcy system on an independent basis. You'd think that the United States would fill that role, but they're the largest creditor of all in throughout the system.
Yes, that's correct. And they make decisions as to what side of the case to come out on in large measure based on the financial interest of the United States rather than on the best interest of the bankruptcy system.
Well, they were opposing you on the Chicago case, right?
They were.
Yeah, because they're a creditor.
That's correct. And that was basically the way they looked at it. If the United States had to seize collateral, as the Internal Revenue Service does, particularly in Chapter 11 cases, they wanted to have the right to hold on to that collateral and not be obligated to return it immediately. Now, again, we had plenty of arguments about that as well. Creditor could always ask for emergency relief from the automatic stay and get a prompt ruling that they were able to keep the property. And they could even seek to have the stay annulled in the event that the debtor was acting in bad faith in filing the bankruptcy case. But our point was, if there was some dispute over adequate protection, the creditor ought to have to raise it by way of a motion for relief from the stay, rather than the debtor having to satisfy that under a statute that says the creditor should give up possession. So lots to talk about there. And we had a good full hour of argument. But as I say, we still have the two remaining issues, A4 of the automatic stay that deals with enforcing a lien, and A6 of the automatic stay that deals with the enforcement of a pre-petition claim. And those may still come to the rescue in the case of our clients.
Well, that's fascinating, Judge. On that score, I've heard it said that you are completely retired, and I want to know what that means.
Well, what it means is I'm taking no new appeals, so I won't be arguing any new cases. And it means that I'm declining speaking engagements. And I've had my share of speaking engagements. But the reason for that is that I want to be spending my time, according to the old cliche, with my family. And there's a particular reason here. I've got a 7-year-old grandson whom I'm homeschooling. I am his teacher. I have 2 4-year-old grandchildren, different offspring of mine, but they're great kids and we take care of them twice a week. So for me to be really doing my job as a teacher, just as a grandparent, it's best that I not be fully involved in bankruptcy. And I have to tell you one other aspect. If you're not fully involved, if you're not checking the advance sheets, if you're not reading the scholarly works on whatever issues are important to you, you lose the edge pretty quickly, is what I was finding, what I'd be afraid of. If I'm going to do it, I want to do it right. Now, I have a couple of appeals that are still pending. And depending on how they ultimately work out, I may have to do a little more work. But other than that, my spurs are off my feet.
Well, on that score, I'm honored. Well, I was honored anyway, but in light of what you said, I'm particularly honored that you're here today with us on this chat.
Well, you told me it would be a short and happy one, and it has certainly been a happy one, Don. And as I said, I've enjoyed talking with you. Any other questions you have?
I'll on that score, I will pause and let you go and say thank you.
Okay. Well, thank you.